ordained by Allah subhanahu wa ta'ala himself. Majority of our fiqh, majority of the Islamic rulings that we have, they're mentioned in the hadith. But mirath is special in the sense that majority of the rulings of mirath, the majority of the rulings of Islamic inheritance are mentioned in the Quran itself. Allah subhanahu wa ta'ala himself mentions that this is how the wealth is to be spent. And when he's talking about these rulings in the verses that Mufti Wahaj mentioned, he mentions faridatun min Allah, that this has been ordained by Allah subhanahu wa ta'ala. Wasiyyatun min Allah, this is your command from Allah subhanahu wa ta'ala. And then he says that these are the limits of Allah. The distribution of assets to different relatives that Allah has defined. He says these are the limits of Allah, and if you follow Allah and His Prophet, you will enter into Jannah, those gardens underneath which rivers flow, and you will remain forever in them. And whoever disobeys these and transgresses these bounds, they will enter into the hellfire and they will live in it eternally, and for them is a humiliating punishment. So this is just to stress the importance of Islamic inheritance. And also, when someone passes away, the assets automatically transfer to the heirs. If the father passes away, his sons, his daughters, his parents automatically become owners of that wealth. And if we don't know the relevant rulings of mirath, you could very well be spending somebody else's money, you could very well be living in somebody else's house when Allah subhanahu wa ta'ala has not allowed that for you. So that's why we felt it prudent to mention the Islamic side of things. So first we defined what is an estate. This is a word that we're going to be using quite a bit. It's any property, whether it's land, immovable property, or it's anything else. Cash, gold, silver, household items. The fuqaha mentioned that even the spoon and the forks that are in someone's possession, these are all included in one's estate. So when someone passes away, every single thing that they own is now part of their estate. And because it is now part of the estate, all the waratha, all the inheritors, all the children or the siblings or the grandparents or whoever the inheritors are, they all own these things jointly. They're all co-owners in these things. And then there are some government funds that they pay, upon retirement, if you were a government employee, they pay you a specific amount of money every month until the day you die. It's if you live for 50 years after retirement, you get paid every month. If you die the next day, you don't get anything. Some of these types of funds, they're not considered a part of your estate. They are considered, these will not be divided. Whatever the terms are stipulated in those funds, the rulings for those funds will apply. It gets very complicated, very convoluted. If someone is in this position where they have funds, retirement funds for their parents or whoever passed away, the best option is that consult a qualified mufti, let him know these are the details of the case, these are the details of the funds, this is how the payouts are, and now how should we distribute these amongst his kids or his wife or his or her husband, whoever it is. So that was the estate. Now, where can the estate be spent? There are four masarif, four avenues in which an estate can be spent. The first is, when the person passes away, you have funeral expenses. The funeral expenses will be paid first and foremost by the person's own estate, unless one of his children, his siblings, or cousins, or whoever it is, says, you know what, I'll pay on my behalf. This will be my one final gift to him. That's a different story. Otherwise, you will take the money from his own estate. If there's money left over after that, then does he have any outstanding debts? Is there any loans that he owed to others and he now has to pay them? Or he passed away before he could pay them? These will be paid for using the money from his estate. And then if there's still money left over, then if he made any bequests, he said, after I die, so-and-so should be given this much money, or after I die, donate this much of my wealth to the masjid or to so-and-so. And finally, if there is money left over after all three of these things, it will be distributed to the inheritors So these are the four masarif, the four avenues in which an estate can be spent. And we'll go into, inshallah, each one of these in a bit more detail. Funeral expenses, cost of the grave, funeral home charges, washing charges, shroud, any of the expenses related to the actual burial. The fariḍa, whatever is obligated on the Muslims to do for the deceased, you can pay for those things using his own money, using his own estate. Whoever has access to his funds can take that money and pay these expenses. Those things that are not obligatory, they cannot be paid for using this money. For example, many people hold memorials or these other events. These are not obligatory events, so they're not going to be paid for using his own estate. If somebody else from his family wants to hold these events, they can do so on their own dime. They can't use the estate to pay for these things. Second is loans. If the deceased had any loans that he had not paid, mortgages, credit card loans, auto loans, he borrowed money from someone, anything like that, he has to pay it. If he has not paid his wife's mahar, the person who passed away was married, and he has not paid his wife's mahar, this is a qarz, this is a loan, a dain, and you have to pay the loan first before moving on to bequests and before moving on to distributing assets. This is a matter that is often overlooked. The husband passes away and there's mahar left. He hasn't paid his wife the mahar, and before the money goes to be distributed between the sons and daughters and whoever else it is, the wife's mahar has to be paid. And especially if, in some cultures we have mahars that are exorbitant amounts. Whatever the amount may be, it has to be paid first before we move on to bequests. Bequests are in the person's lifetime. He said, you know what, after I die, I want you to give this much money to so-and-so person, or to the masjid, or whatever it is. That's one form of bequest. The other is, he's in his final sickness, the sickness that took him. He knows he's going to die. And he's on his deathbed, and a couple days, couple hours, couple minutes before he passes away, he says, you know what, give this much money to this person. That's still going to be a bequest. If a person is in his final sickness, he's on his deathbed, you no longer have the right to transact in your own wealth. You can no longer gift your own money. Spending it for your own expenses, that's a different thing. But you can no longer gift your money in marad al-wafat. So if someone says gift this much to this person, we're going to consider it a bequest. It's as if he is saying, after I die, give such and such money to that person. And if that person does not die from that sickness and Allah gives him shifa and he's fine, then he can honor his own wishes however he wants. If he wants to still go and gift him now that he knows he's not dying, then he can do so. But if he dies in that illness, that will be treated like a bequest. And how will bequests be treated? You use whatever money is left after funeral expenses and after loans. You use 1/3 of the remaining wealth, and you can pay the bequest that way. So for example, a person had $10,000 when he died. You put together all of his assets, and it was $10,000. And funeral expenses, let's say, took away $5,000. And his loans took away another $2,000. What are you left with? $3,000. And then he said, you know what, I want so-and-so to get $50, I want so-and-so to get $100, I want so-and-so to get whatever. And if you add up all of these bequests, it's less than 1/3 of the amount remaining. In our cases, he had $3,000 left, right? So if it's less than $1,000, then good, honor his bequests. Give whoever he wanted to give money, go give them money from his estate. Go give them whatever he wanted them to have. But if he says, go and give so-and-so this much money, go and give that person this much money, and you add it all up and it's more than $1,000. In this case, what do? Everyone, the amount that they're going to get, every beneficiary, you're going to reduce their amount proportionally. So, for example, the total bequests are $1,500, but he's only allowed to spend $1,000. So everyone's bequest will be reduced by 33%. So whoever was supposed to get $300, now he's going to get $200. Whoever was supposed to get, $600, he's now going to get $400. So you proportionally reduce it. However, like let's say, it was $1,500 the bequest he made, and he only has 1,000 to spend, right? 1/3 of his remaining wealth was 1,000, and he only has 1,000 left to spend, and the bequest he made was 1,500. If every single one of the inheritors, every single one of them is a sane, mature adult, in other words, they have every right to transact. They're not children. Children are not allowed to buy and sell. They're not majnoon, they're not mentally deficient to the extent that they're not allowed to buy and sell. They have all the capabilities required to transact. If every single one of the inheritors is a mature, sane adult, and every single one of them say, you know what, we're going to honor our father's wishes or our mother's wishes, and yes, they overestimated how much they were allowed to bequeath, set as a bequest, but we're going to honor their wishes, and we all allow for even more of the money to be spent, more than 1/3, then this is fine. But if even one of the inheritors, even one of them is not sane, he's majnoon, or not baligh, they're a child, if even one of them is not able to give their permission, then it doesn't matter if all of the other ones get together and say we want to do this, just because that one individual is not able to give permission, you can't go past the 1/3 limit. Make sense? And please interrupt me if I'm ambiguous or unclear. I think it's easier that way. So if even one person is unable to give their permission, or let's say everyone is able to give their permission, but one person says, no, I don't want to do it. I don't want to go past the 1/3 limit. And then you can't go past the 1/3 limit. You need every single one of the heirs, the inheritors, to allow to go past the 1/3 limit. So in our case, after paying the funeral expenses, and after paying off all of his debts, he had $3,000 left, and 1/3 of $3,000 is $1,000, so they can honor his bequests up to $1,000. Anything more than that, you need permission from all of the inheritors. And they have to be such that they're able to give permission. And if you can't, then you're not going to honor that bequest. And then if someone, before they die, they make a bequest for their inheritor, someone who's going to get money when it's distributed anyway, but then they make a bequest for them as well, that bequest is null and void. For example, a person dying, he says, I want to give $2,000 from my estate to my son. That bequest is null and void. Or he says, I want to give $1,000 to my wife. That bequest is null and void because the wife inherits anyway. Someone who's going to inherit regardless, bequests for them will not be accepted. They are not valid. And then finally, the distribution to the inheritors. If after paying funeral expenses, after paying off loans, after honoring his bequests, if there's money left over, it will be distributed to the inheritors, and there's specific ratios for it. Spouses, parents, grandparents in some cases, siblings in some cases, children, and then in some cases grandchildren as well, they inherit. The rulings for these are very, very, they're not difficult, but they're very long and elaborate, and we didn't feel it feasible to mention them here. So in the event that someone passes away, find a qualified mufti and tell him that this is how many children he has and grandchildren he has, this is how many siblings, parents, grandparents, aunts, uncles, whatever it is they have, and have him do the math for you. Because it gets very, very difficult at times. And as I mentioned before, the inheritors, they automatically become owners of the estate. Automatically, as soon as the person dies, his children and whoever was supposed to inherit, based on the rules of distribution, whoever was supposed to inherit automatically becomes the owner. Islamically, they are the owner. As soon as the father dies, his sons and daughters automatically, and his wife automatically own his house and automatically own his cars and whatever. They're all co-owners. They're all jointly owning those assets. And so, for example, if he has rental properties or he has investments and he's getting money coming in from those investments, all of these inheritors are entitled to their share of those investments. So, for example, the father dies and you do the math and the son is entitled to, let's say, 20% of his assets, 1/5 of his assets. And for whatever reason, you're not supposed to delay the distribution, but for whatever reason, the distribution was delayed. And a couple months pass by, and now rent checks start coming in, or the stocks start paying dividends, or whatever investment you made is starting to give you profit. So the son will be entitled to 20% of that profit. His sister will be entitled to 10% of that profit. His mother will be entitled to 12.5% of that profit. Whatever the ratios are, if the assets have not yet been distributed, they're going to be entitled to those profits as well. And then finally, disputes regarding the estate, right? The person passed away, and automatically all of his kids and all of whoever was supposed to inherit, they're all inheritors, they're all co-owners of the estate. And now, because they're all co-owners, the Islamic rulings of shirka, of co-ownership, shirkatul milk, will apply. And what does that mean? For example, you have one individual who says, I want to sell the house and liquidate everything. And all the other, let's say brothers and sisters, all the other inheritors are saying, no, we don't want to sell the house. We want to keep it as is and let's see what happens. Let's let it appreciate in value or whatever it is. They say, we don't want to sell the house. Now, this one guy who wants to sell the house, what can he do? He has 2 options or 3 options. The first is that he tells all the other inheritors, listen, I'm entitled to 15% of this house, buy my share out from me. Give me cash, let's settle on an amount, let's figure out an amount, and you give me cash, and I'll walk away. After that, you guys are all co-owners, and you guys figure out what you want to do. I'll walk away. Give me this dollar amount, whatever they agree on, and I'll walk away. That's one option. Second option is that he finds some other third party, not the inheritors, but his neighbor, his friend, or whoever. He says, hey, I got 15% equity, 15% share in this house, buy it off me for this much money. And he sells it to him for that much money. And now the house is co-owned between all of the other siblings and this third party person. Or the final option that he has is he can literally force the liquidation of the asset. When you have joint owners, when you have many owners to the same asset, and one party wants to sell and the other doesn't, you have to sell the asset and then distribute according to the ownership ratios. Because if you don't liquidate the asset, the one who wants to sell, his rights are being violated. And if you do sell the asset, you sell it, the one who wants to sell gets what he wants, and the one who didn't want to sell will get the cash value of that asset. So his rights are not as violated. So this is the fiqhi ruling that if one individual one partner wants to liquidate, wants to sell the asset, and the other one doesn't, the one who is selling, the one who wants to sell, he has these 3 options. And then of course, then he has the nuclear option. He can just say, I'm exercising my power to force liquidation, and we're going to liquidate. And Islamically, the other partners will have to comply. However, yeah, go ahead, please.
Is there a maximum amount that, let's say there's 2 siblings, and the one sibling says, I want to liquidate, let's give me 75% of my share in the house. Is there like a maximum amount that they can request?
Well, I didn't understand. Can you repeat that?
So let's say there's a home, and one sibling wants to liquidate, and the remaining siblings don't. And you said that they can buy out his share, but is there a maximum amount that sibling can request?
No, whatever, it's the sale of any asset, right? You have a car, you want to sell, you can sell it for whatever the market value is. You can sell it for $1, you can sell it for $1 million. It's whatever they both agree on. And of course, as negotiation tactics or whatever it is, the brothers can say, look, the house is worth 100 grand, you own 20%, take 20 grand and walk away. But they can't force that on him. they can't force a price on any of the owners because it's his property and he can sell it for however much he wants. But he can force liquidation of the asset. And then these types of issues, they often come up when, you had one father figure and you had a family home and some of the kids have moved out, some of them haven't moved out, and you have the family home now. And some of the brothers are living there. If you sell the house, they'll be homeless or they'll need to find another place to live. And so in cases like these, again, consult with a qualified mufti. Someone who knows all the different avenues for tasaluh, for finding some sort of settlement, that they delay selling for a valid reason, or they buy each other's shares out, or there's different ways to move forward. But in matters like these, because it's father's house, it's mother's house, it's the last remaining thing we have of them, we shouldn't sell it. No, I need money, we should sell it. The emotions are very high. In cases like these, we always recommend get a qualified mediator, preferably someone who knows the masail, the ahkam, the rulings of inheritance and the rulings of partnerships, and have him sit and mediate between all the parties involved. And it's best to do that sooner rather than later. And of course, I'm sure we've all seen or heard stories of, they delay figuring out the distribution, and 10, 20, 30 years pass by, and now it's no longer the brothers and sisters who are fighting over the house, it's their kids. Now it's cousins fighting amongst each other over the house. And then they delay, and then it's second cousins, third cousins fighting over the house. So it's best to handle these things as soon as possible, and so that we avoid any bad blood in the future. Next, we're going to do some common mistakes that we have seen in inheritance, and Mufti Wahaj will take over from here, inshallah. Yeah.
The point I indicated was like, you keep repeating talk to Mufti after the death.
Yeah.
Most of the problems happen that you can't enforce things after the death.
What do you mean?
You live in America, you need to write your will out before you die, how this will be distributed.
Yeah, so that's the ideal, right? That we're writing our wills out before we die, or our trust, or whatever it is, and we're letting all of these things happen automatically after our death. But the reality is that this is not the case for the vast majority of the cases that we deal with. The majority of people have no trust, have no whatever, and they're fighting in the courts, or they're doing this and they're doing that. That's why like the lawyer said last time he was here, the only people who benefit from going to the courts are the lawyers. That's why if the siblings or whoever the rightful inheritors are, if they have somewhat of a jazba, a passion to do the Islamically right thing, a mufti coming in between them, 8 times out of 10 will solve the problem. And I understand that this mashwara or this advice will not apply to all, but 7 to 8 times out of 10 we see that it benefits quite a bit. That's why I made that suggestion. Yes, go ahead.
Go to the other slide, the bequest one. The last line doesn't make sense. If they are not inheritors at the time of his death, the beneficiary in their favor is none. What does that mean?
Oh, it should be if they are inheritors. That line I wrote it wrong. The last line should be if they are inheritors at the time, bequest cannot be made to individuals who are inheritors at the time of the deceased's death. If they are not inheritors at the time of his death, the bequest in their favor is valid. Instead of null, it should be valid. Yes.
You mentioned about the government funds, which is actually the pension, right?
Yeah.
Can you briefly mention how is that?
So some funds are like 401ks, 457s, 403bs. These kinds of funds, they're cutting a small amount of your paycheck every month, however often you get paid. And then a lot of times, if you're lucky enough, your company will match up to a certain amount. And so it's literally cash going from you to another account and then being invested for you. And then you'll have relatively relaxed tax requirements at the age of 65 or whatever it is. So these types of funds, they're going to be considered estate. And they're going to be, Islamically, they're going to be subject to the exact same rulings of everything that we have mentioned. But then you have some funds that, like the Provident Fund in Pakistan, back in the day, or maybe it's still active, I don't know. But the Provident Fund, for example, it says that, or even now a lot of government employees in Pakistan and in India, they, after someone retires, they're going to be receiving, let's say, $1,000 a month. And if they die before the wife has nothing to do with the company, she never worked, but if they die, the wife will receive $1,000 a month until she dies. And the kids even, until they reach the age of 26 or they get married, they're going to receive those funds. So that money, $1,000 a month or whatever amount they have stipulated. So in cases like these, the rules of estates won't apply, because that money that his wife will receive every month until she dies, that's not in his ownership. He doesn't own that money. Because he doesn't own that money, the ahkam of mirath, the rulings of inheritance will not apply to that money.
So what about that money after the wife passes away? Is that equally or proportionally distributed among the children?
Yeah, so whatever money she has in her coffers, in her bank account, in her wallet or whatever, that the ruling of inheritance will apply to that. But I'm sorry?
It still comes under the estate.
It'll come under her estate. So it'll be her kids and her brothers and sisters and her parents that will benefit, not the husband's kids, siblings, or whatever it is. But even for her, because she died now, she's not going to get any more money in the future. So but her kids are still going to get money. So her kids getting money has nothing to do with her estate, just like her getting money had nothing to do with her husband's estate. Yes.
If there is a property, say for example in Michigan,
Yeah.
and both husband and wife, they are the co-owners.
Yeah.
If the husband passes away, so what will happen, like for the entire property, it will be going to that, or 50% wife keeps and 50% only is distributed?
It depends on who paid for it. If they both paid for it, then yeah, they should both be equal owners. But if they both didn't pay for it, whoever contributed whatever amount towards the mortgage payments or towards the purchase, that's how much they keep. And we've honestly had to sit down and go through mortgage payments and figure out, okay, the wife paid for 47% of the payments, the husband paid for 53%. Islamically, this is what you're entitled to. The 53% should be going to his, or in that case, it was his other wives and his parents and whatever. So it's whoever paid for the asset.
And coming to the like a payout, you said like we have to pay it immediately, right? So what if we say like a specific rules within the trust, you after like at the age of 20 years, 25, 30, can we do that? Like, we don't want to give like all of the money to the kids.
Oh, for minors? Yeah, for minors, that's fine. For Allah subhanahu wa ta'ala says, وَلَا تُؤْتُوا السُّفَهَاءَ أَمْوَالَكُمْ الَّتِي جَعَلَ اللَّهُ لَكُمْ قِيَامًا. That don't give sufaha. In other words, they're minors, they don't make the best decisions. They're going to blow it on something that they're not supposed to, or that they're going to spend it on where they shouldn't be spent. So having that stipulation in your will or your trust or whatever, that's perfectly fine until they reach.
If they are minor, right, at the age of 18 or 21, we had to give it them.
No, whatever. If you feel, even at the age of 18 or 21, he's still not going to make the best decisions. There is some leniency in saying that, until he finishes college or until he does this or until he does that, only then give him or give her access to this fund, right?
I have a question. Are there any different rules, like in inheritance between a will and a trust?
Islamically, they make no distinction, right? However your will is set up, however your trust is set up, it should follow these rules. None of these rules should be violated. But legally, I can't.
I'm talking Islamically.
No, just to add to that, both like a will and a trust, they're both vehicles to allow you to distribute your assets Islamically. They're not going to be treated any differently. Meaning your estate is just like a vessel to hold your assets, and then you write down this is how it needs to be distributed. Whereas a will just says this is how it needs to be distributed, it might need to go through court. But Islamically they're the same because they're a means, they're not the end.
My question.
Yes.
Islamically, the age of maturity is not 18 years.
Yeah.
Just like when somebody becomes.
We're not talking about baligh. We're not talking about bulugha. Bulugha is a biological process. We're talking la tu'tu sufaha. Sufaha means someone who doesn't make the smartest choices, right? When our Qari Ilyas sahab translated that word as bewakoof. Bewakoof ko paisa na diya karo itni jaldi. And so even people who are 20, 25 years of age, we see even today that if they were given this amount of money, it would mess them up. It would, derail the way their life was moving at this point. So that's why it's whatever you feel is the best option going forward. What you feel is the best age to give them, allow them access to that money. Yes.
Sheikh, you mentioned that when the father died, the mother takes the mahar.
Yeah.
But if the mahar like $5,000 in 1990,
Yeah.
and when he died, like 23, the value, what I heard about Imam Abu Hanifa, he said it should be worth the value of something stable.
Because of inflation, right?
It should be the value of that gold.
Yeah, because of inflation. Imam Abu Hanifa has said that, but however, Imam Abu Hanifa said that about that currency which is no longer in circulation. So if they said $5,000 in 1984, for example, $5,000 in 1984 would be worth roughly like $11,000, $12,000 today, for example. But it's still going to be $5,000. If for some reason the US dollar was no longer in circulation, it wasn't being printed anymore, it wasn't a valid form of currency, then you can say, okay, at that time, well, how much gold could you give for $5,000? Okay, let's see how much gold, that's how much gold we will use today. For something like that, you can do it, but for the most part, you cannot just substitute or increase the value based on inflation. It's just like loans.
In many countries, the currency goes down.
Yeah. That's why for the longest time, the muftis have always been giving fatwa, if you want to loan someone money for long term, you're trying to do tabarru'. You're trying to help them out, but you end up losing so much money because the Pakistani rupee is now half of what it's worth. So they say loan in gold. Give him this much, 5 grams of gold, 10 grams of gold, whatever, and say, when you pay me back in gold. Instead of, so you can't make the repayment contingent on inflation, some index, some value of other commodity. This is a form of riba. In loans is a form of riba. In mahar is also a loan, so it's going to be a form of riba there as well.
Upon my question, let's say if I'm loaning somebody $1,000, I loaned 10 years ago, and at that time I said, okay, I will take $10,000 from you. That time, keeping the scenario of Pakistan, $10,000 cost maybe $300K that time. Now they cost
600-700.
yeah, double or even more than that.
Yeah.
So it will be that he should be paying him, let's say, $1,000.
Yeah, he has to hand you dollars. However he gets them, he has to hand you dollars.
My question was, the conference, the purpose of this program is to encourage these people to get into that will or trust program. Instead of, having to go through what the mufti in the hand.
Yeah.
We need to encourage, that's why I think we bring those people here, so we should encourage them to get into that program before the death. They should have will or trust before.
Definitely. That's the main reason we had the lawyer come, Brother Adil Dawoodi. Everyone should be going to him. You're living in a country that has laws and regulations. It's your obligation to follow those laws and regulations so that you are able to implement your rulings appropriately. But the reason we had this program is that when you go to Adil Dawoodi or any lawyer or you're designing your trust, what should you be doing?
Can we do legally and Islamically, can we adjust those things legally here in this country?
Yeah, you knowing the Islamic rulings, you know exactly what I want. I know I have one son, one daughter, one wife, mother and father. And
So local law of land does not affect
not the shares, who gets how much. The local law of the land will not, and the local law of the land does not force you to choose this way or that way. The local law of the land gives you full ikhtiyar. You do whatever you want. Sure.
I think you need to sign one waiver form saying that we are going with the Sharia law. So there will be a separate form that you will sign. So when you go build like a trust or this, so you'll be signing like a separate form. Otherwise, like by default, it will be like a local. So you have to sign the paper saying that
We have had examples where people put in their will that the division of my assets will be decided by Imam so-and-so in Masjid so-and-so. Or whoever the Imam is at this Masjid, he will decide how my assets will be distributed to my heirs. First, you're going to use it for my funerals and my loans and all of that, but how will it be distributed to the inheritors? This Imam will decide that. We've had examples of that. I know there are also templates out there. One option is, I have one son, one daughter, one wife, mother and father. And you just say, okay, you know what, this is what the inheritance rule should be. My daughter gets this much, my son gets this much, my parents get this much, my wife gets this much. But now, what if you have another kid? Or what if, one of the parents passes away? Now you got to go back and adjust that will or adjust the trust or whatever it is. And I know there are templates. I saw one that was like 15, 16 pages long, which included all possible scenarios. If you have one son, one daughter, wife, and both parents alive. You have one son, one daughter, wife, and one parent alive. And it went through all possible scenarios and it says whichever scenario applies, this is how the assets are to be distributed. You can use something like that as well, but only a lawyer could tell you how the efficacy of such a will.
I think the point he is trying to say is that we are three brothers. Two brothers agree, okay, you will decide according to the Islamic one. I don't want, I will go with the law of the land because that is benefiting me more. In that case, it's a good idea that being a father, my father, he should give a waiver at that time, sign a waiver, okay, my inheritance will be distributed according to the Islamic principle from my dad.
Yeah, but that's the issue. There's no standard Islamic fiqh in the US government, right? So if you just say Islamic law, it's open to so much interpretation. So if you mention a specific individual that says, okay, he is going to be the one who decides what money goes where, and whatever he says is my final wish. So if you do something like that, it makes a bit more sense than just, because if you just say Sharia law or Islamic ruling, or even if you say, follow this book, this is the Mirath book in fiqh, it can get a bit convoluted. Yeah.
I'll just add one announcement, and I'll add something to what Mufti Sahib was saying. Number one, we're getting close to Salatul Isha time, so we have chai here, so we can take a chai break, inshallah. We'll pray Salah. Inshallah, we'll come back. We'll have time for questions, inshallah. The other thing is, the point that I think many people brought up, we encourage everybody to set up a trust or a will, whichever one is better for you. The best way to do that is speak to a lawyer, ask them what's a better option for me. The one challenge that occurs is that we respect the laws of the land, no doubt. At the same time, if you look at the laws of the land, they're very broad. And Islamic law is a little bit more restrictive usually, because basically it's between me and Allah subhanahu wa ta'ala. For example, the law of the land is that alcohol is okay, right? I can own a gas station and I could sell all the alcohol I want. I could drink it. I'm not breaking the law of the land. Nobody can sue me or anything for that. But I'm accountable to Allah subhanahu wa ta'ala for it. Similarly, when it comes to inheritance, certain assets, automatically, they may be transferred to so-and-so. You co-inhabit a house with a wife. Automatically, upon death, if her name is on the deed, the house is going to be transferred to her name, automatically. Now the mom, she is bound Islamically. It's her duty to distribute it to who she needs to. Now, if she doesn't do that, no court in America can go after her. Nobody can sue her. She'll just have to be answerable to Allah subhanahu wa ta'ala. The challenge that comes up sometimes with trusts and wills is if a person writes down that 20% of my assets goes to my son and 10% goes to my daughter, and he writes it all down Islamically. The thing is, when a person passes away, the ownership in Allah, according to Allah, of each individual asset is shared. So for example, Inshallah, Allah give you a long life. When you pass away, your house, you have 3 sons, right? Automatically, that house, every portion of that house is going to be owned by your 3 sons and by your wife. And mashallah, your parents are alive, by your parents as well, right? Each of them is going to own some percentage of it. So it's not like, oh, he gets 20% of my asset, and therefore he gets the car, he gets the house, he gets this, she gets this. And that's when the conflict comes up. We know how much everybody has, but who gets what physical assets, that's when these conflicts come up. As far as the reason that Muftis always say have a mufti come in, a lot of times mufti is a code word for mediator. What you're saying is, look, why are you guys going to fight, and why are you going to liquidate this asset? It's your family home. There's a better way to do this. You guys talk, you guys pay him. Look, Islamically, we know that so-and-so is getting 20%, 10%, 5%, but there's a thing called sulah. So all of the brothers, they get together, and all the sisters get together. The brother says, look, I get 20% of the estate. I really like dad's car. Let me take that and I'm out of here. Okay, take the car. If all the other siblings agree, you're fine. Okay, somebody says, I was living in the house already. I really like the house. Can I have the house as my share? The siblings are like, well, the house is pretty expensive. And he says, look, I'll take my share with the house and I'll pay you guys XYZ amount. And they're like, okay, that's fine with us as well. So most of the times, all of it's going to be written down in your will beforehand. The mufti is coming in as a mediator, trying to get it so that it doesn't get ugly between siblings, so that you don't hate each other for years down the line. That's the main thing. If it's all written down in the will, it's going to be distributed, but who gets what assets, that's where the fights come up, and that's where you need some mediation. I hope that cleared it up a little bit. Yeah, they definitely, especially when you have like young kids, right? You're not going to give the kids that money at that time. If there's elders, if they have siblings and stuff, again, the best thing would be to just come to an agreement. If they demand liquidation, again, that's where you try to find a mediator to try to work it out. But if there's like a mother, and Allah forbid if her husband passes away, she has young children, nobody's calling for her to move out of the house and give her children thousands of dollars, right? That would be irresponsible. She's going to stay in the house, knowing that her children own a share in the house. When they get older, maybe they might tell their mom, you keep it. Maybe they say that, mom, when you die, we're going to take the shares from here. Or maybe, she'll downsize when they move out, and then with the sale of the house, she'll give them their amount. So there are, ideally, you would like to liquidate things that can be liquidated immediately. At the same time, though, you have to look at the logistics, like a situation like that. Each situation is different. And again, that's why we're saying, like, it's written down in your trust that so-and-so gets so much. Practically, how are you going to execute this? Again, it helps to have somebody who, again, is respected. Like, when you go and find a mufti or imam, there's somebody who you respect in the community. Somebody who could sit down and get everybody on the same page. Yeah. If they both own, let's say that theoretically they both paid. Yeah. So whatever the wife put in, let's say she put in 50%. She keeps 50%, and only the husband's 50% is up for inheritance, of which she will get 1/8 as well. So she'll be the majority owner of the house. Now let's say she only put in 20%. She's 20% owner of the house. But the easy thing with spouses is, you tell, even if your wife is putting in less, or maybe your wife is putting in more, you say, look, I gift you half of the house. This house is half yours, half mine. If you say it verbally, no matter what it says on the title, between you and Allah, so she owns that. So if you say you own 50% of the house, and when, inshallah, you'll be around for a long time. But if a husband passes away, then again, she'll get 1/8 on top of the 50% that she has, or 1/4 if they don't have children. And then the children will get the rest from that 50%, inshallah. So, yes, last question, and then we'll pray salah and drink chai, then we'll come back.
So, as you said, verbally saying that you own half of it. Would that not cross the 1/3 of the bequest then?
No, because that's in lifetime. So you're telling the wife, I owe you, I'm giving you half of the house. It's yours now, right? So it's not, bequest means after that. If you told your wife, you will get one half of the house after I die, that would be bequest. If
Can I give, say, head of the household, man, can he say that 50% of my estate right before his deathbed, give it out to charity, and leave just 50% for his family before it can?
he can't do that while he's alive or when he's passed away. He said, can somebody say, let me give 50% of my wealth? Whether it's on the deathbed, whether you're alive, is 50%, that goes beyond 1/3, right? So you're saying, after I die, give 50% of my wealth away, of my estate away. That's not allowed. Oh, while you're alive? You could do that, but Nabi Sallallahu Alaihi Wasallam didn't advise that to be done. You're allowed to though, because it's yours. Okay, Jazakallah, after Salah inshallah.